What's up, everyone? It's Peter Tragos, the lawyer you know, and we have finally gotten to the beginning of the Curtis Reeves trial here in Pasco County, in my backyard, the movie theater shooting by the former ex-law enforcement officer. Opening statements are happening today, and we're gonna do something a little bit different, where I actually react to the state's opening statement as it's happening. I have not watched it before I watch it here with you, so this will be my immediate reactions and responses, and I'm going to give you some background into why the state is making certain arguments, why they're bringing up certain facts, whether or not they're arguing versus just saying what the evidence will show, as we know is the proper thing to do in an opening statement, not an opening argument. But it's going to be fun to watch this together for the first time, talk about why trial lawyers set cases up the way that they do, and what some of the theories are that the state's going to go with at this point that we may not know or may not have thought of beforehand. So it's going to be fun to go through this opening statement together. If you guys enjoy this video, please hit the like button and make sure you subscribe to our page, because we're going to be pulling clips from this trial all week, or actually for the couple weeks that it's going on, and reacting to certain parts to really give you some behind the scenes look as to what trial lawyers do and think as they try cases like this. Mr. Rosenwasser, who she just introduced, Scott Rosenwasser, is a good state attorney, really good dude, and he's, representing the state, the people of the state of Florida in this case. So I expect it to be a good opening because I've tried cases with him and been in the courtroom with him before, so I know kind of how he presents. So I expect it to be a good opening statement. We'll see how it goes.
State, Mr. Rosenwasser.
Members of the jury, what you're going to learn during the course of this trial is that back on January 13th of 2014, Chad and Nicole Olson decided to spend the day together. It was a Monday. They had not been spending that much time together based on their work schedules. They were also raising their daughter Lexi, who at the time was just under 2 years old. So they decided on that day that they were going to put Lexi in daycare and go out for breakfast, possibly shopping, maybe over to Wiregrass. And eventually, at some point on January 13th, they decided to go to the Cobb Grove Theater. They were going to see the movie Lone Survivor.
Okay, so right off the bat, he takes a very common theme and common way to start your openings, especially as a state attorney, and that is to set the scene, give the facts, humanize the victim, and let everybody know he's a family man and he was making decisions to spend time with his wife. They're raising their daughter, so he has a young daughter who needs daycare. He also mentions a couple local spots like Wiregrass and Cobb Theater, because these jurors will be from the area and they'll be able to say, okay, yes, I know where that is. And as he's setting the scene and setting the stage, they can understand and put themselves in the victim's shoes, which is what he is going to do by setting the scene and setting the stage here in this opening statement. So he's going to tell kind of what happened step by step and take them through a timeline to set the scene, which is a very common way state attorneys do opening statements in criminal cases like this.
That was going to start about 1:20 in the afternoon. Now that's located at 6333 Wesley Grove Boulevard in Wesley Chapel here in Pasco County. So what you're going to learn is that they go to the theater. When they get there, they purchase their tickets. They then go inside to the concession stand and they buy some snacks. After that, they decide to go into the theater. Now this theater is theater number 10. And what you're going to learn is that theater number 10 is a Cinebistro. It's a general theater and a Cinebistro. And you may know what a Cinebistro is, but basically it's an area of the theater where you can order food kind of like in a restaurant setting. You don't have to go to the concession stand. And this particular part of theater number 10 is separated from the general theater by a wall. In fact, there's a separate entrance. Now, what you're going to learn is that when Chad and Nicole Olson decided to go into theater number 10, they were looking for some seats that were towards the back of the theater. That's where they like to sit. So they chose the row that was to the second to back last row. And they went over towards the middle. Nicole Olson sat down, and on her right was Chad Olson. Now at this point in time, there wasn't that many people in the theater. People were still coming in. They had their snacks, they were talking.
So it's interesting. The way he sets the scene is the victim and his wife come in, they sit down, they pick their seats, and there's not a lot of people in the theater yet. So I'm assuming he's going to say that the defendant chose to sit right behind the victim. But the victim was there first, and I think that's important in how they're trying to set this scene and who created the problem in the altercation.
And at some point in time, one of them, doesn't matter who, one of them wanted some more snacks of some type of candy. Chad Olson gets up, leaves the theater, goes back to the concession area, and of course more and more people are coming into theater number 10 to see the movie. When Chad Olson comes back, he sits down. Again, he's still on Nicole Olson's right. And at some point in time during this, the defendant and his wife, whose name is Vivian Reeves, comes into the theater. Now, when they come into the theater, they decide to sit in the very back row. Now, there's a wall behind them, because behind that wall is where the Cinebistro area is. They go to the very back row, walk all the way across to the middle, and they sit down. Now, to kind of paint a picture for you as to where everybody's seated, and you're going to see this in video, and people are going to tell you where they were sitting. Picture this. So, in the very back row, you're going to have the defendant. He's sitting in the middle. Directly in front of him is Nicole Olson. To Nicole Olson's right is going to be Chad Olson. Behind Chad Olson is the defendant's wife, Vivian Reeves. So stated another way, to picture it a different way, you have the defendant in the very back row, basically in the middle.
So, as I expected, he says the defendant came with his wife and chose to sit right behind the victim. The defendant was sitting in the back middle, and he said exactly where everybody's sitting because the jury is there. The jury is understanding how this day is building, and they're now sitting in the movie theater with the victims and the defendant.
An entire row in front of him and an entire seat over to the right is where Chad Olson is sitting. That's the layout of the theater on this particular day when this shooting occurs. Now,
an entire row in front of him, an entire seat to the right. So I'm assuming he wants that to sound like a lot of space. I don't know where he's going with it yet, but if I was just going to say just a row in front of him and just one seat over, I could make it sound like a little bit of space. And again, that's how trial lawyers work. We use words specifically to explain the situation. And in this case, I think Mr. Rosenwasser here is trying to say an entire row in front, an entire seat to the right, meaning that's far away. Because words are important here and definitions are important. And he is going to define what that means here.
Now, what you're going to learn is that there were many people that came into the theater. In fact, at the beginning of jury selection, a long, fairly long witness list was read to you. And you heard from the court and you heard from us that you're not going to hear every single witness that's on that witness list. Because there was a fairly large law enforcement response, and not everyone in the theater has relevant information. Some people became aware of the shooting afterwards, some people didn't see anything, some people didn't hear anything.
Why bring this up? You read all these witnesses, you said you might not call them all, why bring this up? Well, as a trial lawyer, one of our fears is, especially if you're the state and you have the full burden in this case, you don't want the jury to think, why didn't they call all 73 people that were on their witness list? Well, you have to explain to the jury that the people you don't call don't have relevant information. Now, I would object to that as the defense attorney. Because do we know that that's true? Did we talk to every single one of these people? Are you only calling people with relevant information? Because if I call someone as a defense attorney that you don't call, I believe they have relevant information, but you don't. Maybe you're just not calling them because they don't say something that's good for you. The defense doesn't object. So the state gets to explain right off the bat, we may not call some of these people, and here's why. It's not because we have anything to hide. It's not because they have anything bad to say about our case. They just don't have any relevant information. We're going to call everybody that has relevant information about this case to explain it to you. So he's explaining why they're not calling these witnesses, which is important. You never know what a juror is going to hang on to. And you don't want them to hang on to, why didn't they call every single person that was in the movie theater? He's answering that question right up front.
And some of the law enforcement officers were there for basically security. So you're not going to hear from every single person. The people that you are going to hear from, they have different parts of the whole picture, meaning this. Some of the witnesses that you're going to hear from heard the beginning of what happened. Some heard the middle, some heard the end. Some saw the beginning. Some saw the middle, some saw the end. Some heard and saw basically everything. Now you are going to learn that there is a video. And by video, I mean just that. There is a video and not an audio.
So why say that? Why say just a video and not audio? Well, in every single criminal case in jury selection, ever since CSI, basically, the state asks, do you have to have DNA? What kind of evidence do you have to prove a case beyond a reasonable doubt? And if the jury sets that bar too high or doesn't think witness testimony is enough, they can get struck. So when you have evidence like a video in the case, you want to set the expectations of the jury. If they're going to watch a video, they're going to expect to hear audio. So you let them know there's not going to be audio. It's just going to be video. You're just going to be able to see it so that when they see it, they get exactly what they're expecting. And it's all about managing the jury's expectations as the prosecutor or the plaintiff, the one that has the burden of bringing this case. So he's telling them right up front, it's video, not audio.
The video comes from the Cinebistro area. There are 2 cameras inside of theater number 10 on opposite sides of the theater. Now, they were designed, as I mentioned, to capture the Cinebistro area, but they did capture some of the general part of the theater and did capture this shooting. Did capture people coming in the theater, did capture people leaving the theater, the defendant leaning in and talking to Chad Olson, things of that nature. The video did capture that. Again, there's no audio. The audio is going to come from witnesses. Now, what are you going to learn? Well, people are going to tell you what the lighting environment was. So people in the theater are going to tell you the following. Now, don't pay particular attention to any single one-word description because you can't adequately describe something in one word. In other words, to be pigeonholed to one word. For example, in everyday life, if someone were to tell you that someone was of a medium build, well, one person might think of that as a thin person, and another person might think of that person as a heavier person. But the description, when people elaborate, that's how you're going to be able to determine exactly what happened. So in this case, what are you going to hear from people that were in the movie theater? You're going to hear that at the time of the previews, now, this shooting occurred.
Hold on, before we get any further, what did he just do there? Some people describe somebody as a medium build. Others would describe him as heavy. Somebody else might describe him as thin. So people all have kind of different ways of describing the same thing. He is setting the expectation that if there are minor discrepancies in the witness testimony about describing certain parts or events, he's explaining. Remember when I said in opening that people can describe things a little bit differently? Even though this isn't evidence, it is a trust builder. And when things go exactly as you say they go in opening statements as a trial lawyer, the jury trusts you and believes you. So when you let them know that there may be some differences in how somebody describes a surrounding area, but that doesn't mean it's inconsistent. That doesn't mean it's a lie. That doesn't mean it's not true. He's setting that up right now.
During the time of the previews. So when I talk about the lighting conditions, it's the same during the time of the shooting. So what witnesses are going to tell you is that it was light enough for them to see in the movie theater. The lights weren't full, they weren't full house lights. It had been dimmed. So if you hear the words dim, dimmer, pretty dark, darker, that sounds like it's painting a different picture. But I submit the evidence is going to show you that when everyone came into the theater, their overall description, forget the one word, was that they could see.
Interesting. So now we know what he's saying. So the size of the person is not the discrepancy. It's how dark or light it was in the movie theater. So you're going to hear the word dim, dimmer, dark, darker. That doesn't really sound like light, but that's what he wants it to sound like. And he says you're going to hear that they could see. And that's important because I assume he's going to say it was light. So the defendant was just a jerk when the victim was on his phone and it was actually light. Like it wasn't even the dark part where the movie was happening. And he's saying that's how everyone's going to describe it, even if it is a little bit of a different description of dim. Very interesting to me.
They could see aisles, they could see rows, they could see seats, they could see people in those seats, even at a distance. They didn't have any concern during these previews. Again, this was the time of the shooting, that they needed a flashlight or their phone to offer some light for them to navigate in the theater. It wasn't dark like when the movie starts.
It wasn't dark like when the movie starts, meaning that's when it's okay to be annoyed if somebody's on their phone. But that's not what this was. That's not when the shooting occurred.
That's the lighting conditions at the time this shooting takes place. And that's the lighting conditions you'll learn about when Chad Olson is on his phone. Now, what happens? The previews start. People are seated inside the theater. Again, you have the defendant in the very back row in the middle. In front of him is Nicole Olson. Over to her right is Chad Olson. Behind Chad Olson is Vivian Reeves. The previews start, and there is a message that you should turn your cell phones off, basically. Now, here's what you're going to learn. Chad Olson had his cell phone on.
It's interesting. Again, admitting bad facts in opening. It was light. The previews were going, everybody could see, no big deal. But the message did come that said, turn your cell phones off. So if it was so light and no big deal that his phone was on, why did the message come saying turn your phone off, right? So that's not a great fact for them. But so far, no real argument. He's just setting the stage and he's telling a story. I think it's a great opening so far. You're dealing with some of the bad facts, but I'm following along with him. I think it's going well. Let me know in the comments at this point. Give a thumbs up or a thumbs down emoji in the comments as to how you think Mr. Rosenwasser, the state attorney in this case, is doing in their opening statements. Let me know.
Now, by on, this is what I mean. Chad Olson, the evidence will show you, he's not talking on his phone. He's not conducting a business transaction. He's not talking to a friend, a family member, not having a loud conversation. By on, literally the phone is on. That's it. The evidence will show you that there was a white light coming from the phone. That's how the phone was on. You're going to learn that almost immediately or very close after the time of that message, please be responsible, turn your cell phone off, whatever the message is. Very close in time to that, without really waiting, the defendant over here leans in to Chad Olson and Nicole Olson. Because the evidence will show you the cell phone had a light on it. Now, what you're going to learn is that this defendant leans all the way in, and it's going to sound silly when I say this, to Chad Olson's personal space. And you're going to see this on video because it's captured. Not only is a witness going to talk to you about it, but it was captured on video. The defendant leans all the way in from his seat and basically gets back to the left ear of Chad Olson. So the defendant's head is basically in their space. You're going to learn from a witness that the defendant's tone was kind of demanding. Turn your cell phone off. Now, at that point, the evidence will show you they're kind of taken aback by this. Now, Chad Olson did not turn his phone off. Now, here's what you're going to learn what was going on that phone. He was looking at Facebook.
So he was looking at Facebook is what they're saying. They're going to tell you what the victim was doing on the phone. But what they're doing now is setting up that the defendant, they're doing the generally bad guy rule. They're going to say he was demanding, he was angry, he was mean, he was going overboard. They're going to show this was no big deal and normal people wouldn't have cared, but the defendant was a jerk, so he cared. That's what they're trying to set up with this factual scenario. Again, no argument yet. So he's just setting up the facts and trying to let the facts tell you, the jury, that the defendant's a jerk.
He was looking at Facebook. Social media. There was a website that he was looking at through Facebook. And they had been looking at it. The evidence will show you, of course, that's no reason to shoot another man. But here's what you're going to learn. That the defendant leans all the way forward, tells Chad Olson to turn his phone off. Chad Olson doesn't turn his phone off right away. Now, in a perfect world, should Chad Olson have turned his phone off? Yes, but the evidence will show you that you can't kill someone for that.
There's our first bit of argument. Should Chad Olson have turned his phone off? Sure, but the evidence will show you can't kill someone for that. Okay? So that's argument. That's the ultimate issue. Did the victim's actions necessitate a deadly force response by the defendant? Now, I think it's obvious the answer is no. Looking at your phone doesn't mean you can get shot for that. But the evidence isn't necessarily going to show that. The argument is going to show that. So that's his first bit of argument. But he even said, before he made that argument, he said the evidence will show, which is like a little crutch or tick that some lawyers have before they're going to make an argument. They say the evidence will show, hoping the judge just hears that. And if they're objected to, the judge says, no, he said the evidence will show. So just a little nitpick there. But good move. I mean, I think you got to show the jury and tell the jury what exactly the evidence is going to show.
Now, the evidence will also show you this, that the defendant waited a little bit, asked him again to turn his phone off, then got up to leave the theater. Now, the way he left the theater is going to be important for you to consider during the course of this trial. The overall attitude and demeanor of the defendant that's going to be described to you during the course of this trial is very important. Because one of the charges the defendant's been charged with is a crime called murder in the second degree. And all of these laws are going to be explained to you at the conclusion of the case when the judge gives you all of the instructions. But a part of murder in the second degree is that we have to prove that the defendant acted with ill will, hatred, spite, or evil intent. ill will, animosity, bitterness, spite, annoyance. So the defendant's demeanor and his actions will play into whether or not there is ill will, hatred, spite, or evil intent. So here's what's important about when the defendant gets up to go tell the manager.
It almost sounds like he's defining generally bad guy when talking about second-degree murder. And I don't know if you remember the beginning of the opening a few minutes ago, he was a little quick, the prosecutor. He was a little quick in starting the story. He has settled in perfectly, and his cadence and his speed and methodically going through things now is just the perfect cadence in my opinion. And now we're getting into exactly what happened. And the defendant's demeanor, you think it's going to be good or bad? My guess is it's going to be he was annoyed, demanding, stomping around. That's what the demeanor is going to be that he's describing now.
That this white light is bothering him during the movie previews. The defendant gets up, and as he goes out the aisle, he's mumbling to himself. Now, you're going to hear from a witness who's going to tell you that based on her life experiences, he appeared to be agitated and angry. The evidence is going to show you that he was.
Agitated and angry, surprise, surprise.
He was annoyed that Chad Olson still had that phone light on. And he walks out, he's mumbling to himself. Now, as he's walking out fine, meaning this. Whenever anyone navigates through an aisle or a row in a movie theater, you necessarily have to move around people, and it's kind of awkward. But he was able to do that.
He was able to walk out fine. He was able to maneuver that fine. Why do you think he's saying that? Well, we have heard in motions in limine, in voir dire, and in other hearings that the defendant was frail and weak as an old man, and that's why he was so scared. So the state's coming right out saying he was fine. Watch him get up and walk. He's fine. He's not a frail, weak old man. He's a former law enforcement officer. So that's an interesting, they're bringing that out right in the beginning, and we get video evidence. So we get to see him walk out of the movie theater.
There's a video that you're going to see that shows him getting up and walking out of the theater. People watch him leave the theater. Remember, he's in the back row, goes all the way down the steps. There might be 13 rows. You're going to see pictures, you can count for yourself. Walks all the way down the ramp, all the way to the manager's desk. Now, when he's at the manager's desk, what happens? Well, when he's there, and again, there's no audio, there's going to be just a video, watch his demeanor. Now, I don't mean to present to you, and I'm not painting the picture to you that when he's at the manager's desk, he's banging on the desk and screaming and demanding action, because he's not. But when we're talking about the demeanor of the defendant, the evidence will show you this ill will or spite. Watch his arms, watch his hands, watch his fingers, watch his facial expression. He's there for about 3 minutes, walks back into the theater, all the way up the ramp, around the corner, all the way back up to the back row, all the way across again into the middle. Now, the witnesses you're going to hear from are going to tell you this. They're going to tell you that the defendant did not appear to have any disability. He didn't have a cane, didn't have a walker, didn't have a wheelchair.
Once again, hammering home, not a frail, weak old man.
The evidence will show you, and it sounds like a silly thing to measure, the defendant parked 133 yards away from the theater. Now, it sounds silly again. It's a football field and a third, but there's no handicap placards. The defendant's not handicapped. Wife didn't have a handicap placard. You're going to see video of the defendant as he purchases tickets. He's in the lobby area, in the concession area, walking to and from the theater. Now, why is that being brought up? Well, the evidence is going to show you this, and we're going to talk more about it in just a little bit. But the defendant gives a taped statement to law enforcement, freely and voluntarily waives his rights, and there's going to be a picture painted during this taped statement. And one of the things you're going to learn in this taped statement is the defendant states he's got arthritis in his back and his knees. Well, the evidence will show you that, let's say that's all true, it's very, very bad. The evidence will show you that's no reason to shoot and kill another person. However,
once again, that is not what the evidence is going to show. That's an argument. The argument that arthritis and whatever, which in my opinion cuts hugely in favor of the defendant if he did say that the night or just recently after the shooting, that makes it a lot more viable if you think back to Ahmaud Arbery and where they kind of just made up defenses later on. Doesn't seem like that's the case here.
However, when you see the actual pictures, meaning the video, and you listen to the witnesses, you're going to see he was completely fine. Now, what happens? When he walks back into the theater after speaking to the manager, coming back across the row. Now, it doesn't matter exactly when this happens. It's either as the defendant comes back into the theater, as he's sitting back down, or even some seconds after he's fully seated in his seat. Doesn't matter. But the defendant in this taped statement indicates that he reinitiates contact with Chad Olson.
And we know who starts the confrontation, right? Who is the instigator? That's important in these self-defense cases. The defendant, by video, is the one that continues to initiate contact with the victim, not the other way around.
Now, what's the evidence going to show you in this case? Chad Olson was talking to someone earlier, and it was the person in the row in front. At no time will the evidence show you that Chad Olson is volunteering to talk to the defendant. The defendant's always the one initiating the conversation. And as the defendant comes back, based on his own statement, he indicates that he reinitiates contact with Chad Olson and tells him this. And here's something that's important you're going to learn during the trial. Chad Olson did, in fact, turn off his cell phone. The phone was off when the defendant came back into the theater. The evidence will show you that the defendant could have just sat back down in his seat and everyone could have watched the movie and everything would have been fine. The phone was off, no problems. The evidence will show you that after there's a conversation, Chad Olson is in his seat. Now, what the defendant states to Chad Olson is, "I see you put your phone away. I told the manager for no reason." Now, I submit the evidence will show you that there was no reason for that. Regardless, the statement was made. Based on the defendant's own statement, Chad Olson turns around in his seat. Now, when you listen to the defendant's taped statement, pay very close attention to the words he chooses to use and the order in which he uses these words. The defendant states Chad Olson turns around in his seat, and now Chad Olson says some words to him. Now, in a perfect world, should that have happened? No. The evidence will show you can't shoot someone for that.
Once again, the evidence will show you can't shoot someone for that.
Chad Olson does turn around and starts to have some words with the defendant. "Mind your own business, leave me alone." There might be an F-bomb in there. And at some point, very close in time, because this is all happening fairly quickly, it's fluid, Chad Olson stands up and continues, and he looks at the defendant. Chad Olson's in his row. Remember, he's an entire seat in front of the defendant. An entire row in front of the defendant, and an entire seat over.
So now we figure out why he's saying an entire row, an entire seat so far away, as to show that he was not in imminent danger. The defendant was not in imminent danger. Chad Olson was so far away that even if he wanted to do something to the defendant, he would have had to navigate this row and seat just to get there to do anything. So therefore, no way it could be lethal force. That's why he's using the terminology of an entire row and an entire seat.
And during this conversation, while he's standing up, he says, "If it's any of your business," and there may be an F-bomb in there, "I was texting my daughter." Now, the evidence will show you that he was on Facebook.
Interesting. So the victim technically lied. He told the defendant he was texting his daughter, but he was on Facebook. That is immaterial and doesn't matter at all. But would you care? If you were on the jury, would you care that the victim lied while he was standing there? I wouldn't at all as a lawyer. But some people, I think, would care about that. So the prosecutor's trying to deal with the fact that the victim did, in fact, lie to the defendant right before he was shot.
The evidence will show you that under the law, whether he was on Zillow, buying a car, buying a house, checking the stock market, Facebook, texting, you can't shoot and kill somebody. It's irrelevant. I submit the evidence will show you he was just trying to get the defendant to leave him alone, and that's what he chose to say.
Again, that's pure argument because I assume that the victim is not going to testify in this case. Obviously, we know he's not here. So how are you going to get in the victim's head? He was trying to get the defendant to leave him alone. I don't think there's going to be any evidence of that. That's just an argument you're making to the jury. Again, I'm nitpicking because we're sitting here reacting and breaking it down together. I'm just thinking the victim's not going to tell you why he said that to the defendant. Could have been an objection by the defense.
Really doesn't matter. So the evidence will show you this. Chad Olson is standing up. And as he's standing up facing the defendant, and you will see this on video, Chad Olson reaches over with his right hand. And he reaches over into the defendant's lap and he grabs something. Now, this might sound silly. What does he grab? Does he grab a deadly weapon out of the defendant's lap? The evidence will show you absolutely not. Does he even grab a big tub of heavy popcorn? No. Here's what you're going to learn during this trial. Chad Olson reached over with his right hand into the lap area of the defendant and grabbed a bag of popcorn. And he grabbed that bag of popcorn and he brought it back and he flicked it at the defendant. Now, the evidence will show you, of course, in a perfect world, should Chad Olson have grabbed a bag of popcorn and tossed it on the defendant? Well, of course not. The evidence will show you can't shoot and kill another person over that. So the evidence will show you this, because there's a couple of things happening simultaneously at this point. So I want to break it down just a little bit. Chad Olson stands up. He's facing the defendant, says something about texting his daughter. He reaches over, grabs the bag of popcorn, and flicks it. Doesn't pull it back, isn't using it like a bat, just flicks the popcorn on him. His hand is now coming back. At about that very same time, Nicole Olson, remember, she's sitting in front of the defendant. She's starting to reach over with her left hand while this is happening. And in the process of getting up to say, honey, it's just sit down. So her hand's up. When her hand is up, and while Chad Olson's hand's coming back from that popcorn toss, this defendant shoots. So taking a step back to kind of go over what happened. The evidence will show you Chad Olson is sitting in his seat, turns around, says a few words to the defendant. Stands up, says a few words to the defendant, reaches in, grabs the popcorn, flicks it. Now, this is important to watch on the video because it goes back to arthritis, my back, my knees. What you're going to see on the video is the defendant, in an incredibly quick and swift maneuver, reaches his right leg out as he's leaning back, goes into his pocket to get his firearm that he's brought into the theater, pulls it out, and lunges forward to shoot Chad Olson.
So his first explanation of the shooting here that we got, he makes jokes, and I don't mean makes jokes meaning makes light of it, but he's like, he didn't grab a weapon. He didn't even grab heavy popcorn. He grabbed a bag of popcorn. That's it. No deadly weapon, no deadly force. He threw popcorn at the guy, and then he shot him, which I think is the best way to resonate with the jury that this was nothing. Getting popcorn thrown at you does not necessitate deadly force.
The evidence will show you he's not back cowering in fear, but watch the manner in which he grabs his firearm, how quickly he is able to do it, how fluid he's able to do it, and how he lunges forward as he shoots. And why is that important? Well, to go back to the instruction of ill will, hatred, spite, or evil intent. The evidence will show you he was mad. Chad hadn't listened to him, and Chad threw popcorn on him. So, what happens next? After that, Chad stumbles. He begins to turn to go towards the aisle. He goes down a couple of seats. He's shot in the chest. He can't make it to the aisle even. He falls down on other people in the theater. Nicole Olson's finger is almost shot off. It's almost severed from the bullet going through. She's screaming. Chad falls on the ground. There happen to be nurses and other people there that try to help Chad Olson as he's laying on the ground with that bullet in his chest. Now, ultimately, of course, Chad Olson dies. He's basically dead in the movie theater. There happened to be an off-duty deputy, not from the Pasco Sheriff's Office, but from another county in the theater. He gets up, you're going to see this on video, and he walks over to the defendant. The defendant has his gun on his lap. It's taken from him. The gun eventually is given to a sergeant at the Pasco Sheriff's Office. That gun is eventually sent to a place called the Florida Department of Law Enforcement. Now, during this trial, there's going to be some stipulations. Stipulations are agreed upon facts, so to speak. You get these, there's not going to be any other testimony on the matter. They're basically just accepted to. Now, one of the stipulations you're going to learn is that this firearm, the one the defendant used, it's a .380, was sent to the Florida Department of Law Enforcement. There's a shell casing there. Shell casing came back to that gun. Now, that's not an issue in this case because this is not a whodunit case. The important part of that stipulation is that this firearm, the one the defendant brought into the theater, was working properly. Didn't malfunction, wasn't an accidental shooting. This was an intentional and purposeful shooting. The gun was working fine.
And that's important because as we've seen in other trials, that's the bait and switch, right? It's like, oops, it actually accidentally went off. Well, they made sure to have it tested and they stipulated that it was not accidental, so we're not going to have a Theodore Edgecombe, I accidentally shot him so we can get a lesser included. Not in this case. And these prosecutors did their jobs and got rid of that right from the jump. You're not going to argue that. We're going to stipulate to it right from the jump 8 years ago.
Now, people are working on Chad Olson. This other deputy is with the defendant. People call 911. Now, you can imagine when there's a 911 call about a shooting in a movie theater, there's a fairly large law enforcement response, and there was. And this is when the investigation begins. Now, people that were in the theater, they go to different parts of the theater. Some are in front of the screen, some are in the concession area, the lobby. Now, fire rescue was called. They had to what's called stage, meaning they had to wait for the movie theater to be secured before they could go in to try to help Chad Olson. When the deputies came in, they made sure the scene was secure. They were trying to help Chad, dealt with the defendant. Fire rescue comes in, everyone goes to the hospital. Chad's life can't be saved. Eventually, Nicole has work done on her finger. Now, while deputies are there and people are in different parts of the theater, they hand out these blank forms. And sometimes they're called written statements. And people are not given any instructions on how to fill these out. They're just told to write down what you know. Now, of course, these are people in a theater who aren't law enforcement officers or lawyers, and they don't know how much to write or how little to write. Some people write one sentence, some write 10 sentences. It's basically just what they saw. Some people are going to tell you they're really upset by what they saw. And law enforcement used this as a first step in their investigation. Read those written statements, tried to figure out who they needed to talk to in some type of order. Who they were going to talk to that day, who they were going to follow up with later on. That's what happened with the written statements. Now, when people filled out these written statements, some people were near them, but no one was telling other people what to write or what to say. The witnesses that come into court are going to tell you what they personally heard and what they personally saw. That's it. Now, witnesses were interviewed. The defendant himself gave a statement, as I mentioned. He gave a tape statement. What the evidence will show you is that Chad Olson was shot and killed over tossing popcorn. The defendant's statements are fairly consistent with other testimony and other evidence, including the video, up until the point of time of the shooting. The evidence will show you that the defendant's statement is not accurate as about what had occurred, based on what you're going to view during the course of this trial. So what did the defendant tell the police? The defendant tells the police that he went to the theater. Obviously, he did. While he was in the theater, he saw Chad Olson had his phone on. Now, the defendant states he leaned forward and was being nice, asking him to turn the phone off. When Chad Olson did not, he got up and he went to tell the manager. He came back. The defendant says that when he came back, he did talk to Chad Olson, and he told him the statement that I represented before. I see you're not on your phone anymore. I went to tell the manager. He says, and again, the words he chooses are very important. You're going to learn that he was former law enforcement, so he knows the importance of the accuracy of words. He says that Chad turns around in his seat, and at that time, there's some words between them. He then indicates that Chad Olson jumps up. Now, here's where I submit to you the tape statement has maybe two different statements, and this is where you're going to have to critically analyze this tape statement. It seems as though the evidence will show you that the defendant states nothing at all about the popcorn in the beginning, as if that event never took place. Now, you're going to learn with his glasses on, the defendant's got 20/20 vision. Can't really miss anything. What the defendant states is that Chad Olson is coming over on top of him. Okay? So when you listen to the tape statement, at first it appears as though the whole popcorn thing never happened. Later in the tape statement, the defendant states when Chad Olson jumped up, the popcorn fell almost immediately. Well, the evidence is going to show you that after the popcorn fell, that's when this defendant immediately took out his firearm and killed Chad Olson. So the evidence will show you that tape statement's not exactly true. He says that when Chad Olson jumps up, the popcorn fell immediately. And this is the picture painted in the defendant's tape statement. Here's what the evidence will show you. The defendant states he's in his seat. Behind Nicole Olson, remember, Chad Olson's one seat over to the right. One row down, one seat over. He's back in his seat, and he's got his left hand up, and he's yelling, no, 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 or whoa, whoa, whoa. This is the picture the defendant's going to paint on this tape statement. And he's back in his seat, and Chad Olson is coming over the seat, and Chad Olson is virtually on top of him. In his lap. Those are the words the defendant himself uses.
This is why, even if you're former law enforcement, when you give a statement that's inaccurate to law enforcement, it will be used against you, especially when they have video evidence that shows what you're saying is false. And Scott, the prosecutor, is going to focus on this because that is so important, and that shows the defendant lied to try to make it sound like it was legitimate self-defense, when in fact, we all know, basically, is what the prosecutor's going to argue, we all know it wasn't.
Virtually on top of him, his lap, and he's got his left arm out, and he's touching his arm or his shoulder, but he really believes he's touching Chad Olson's chest because he's so far into him, into his row. And at that time, he has to straighten his right leg out, pull out that firearm, and kill him. The defendant states he's surprised he didn't shoot his left hand because his left hand was so far out when he took that shot. He's surprised. The evidence will show you that is not exactly what happened. There will be no witnesses that will come in here and tell you that happened. No one heard any yelling, screaming, any type of fight like that, life or death struggle.
When it's the defendant's statement versus all the other evidence, not a great start for the defendant, but a great point to point out by the prosecutor.
You're going to hear about a term called stippling during the course of this trial. Stippling, and this might be a really bad description of it, is when a firearm is fired, material comes out, hot material, and anything that's close in its way gets these embers, so to speak, and there's a burn mark on skin. Now, you will see stippling in this case. The evidence will show you there was stippling on Nicole Olson's hand because it was in front of the firearm when her finger was almost shot off. You're going to see stippling on Chad Olson's wrist because when he brought his wrist back after tossing that popcorn, you're going to see stippling all over there. But the evidence is going to show you there's no stippling on the defendant's left hand. The evidence will show you that's because his left hand was not out. No, 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 you got to get off of me. That's what the evidence is going to show you. Now, after the defendant fires the shot, there's some important words that people in the theater hear. And these are people that don't know each other, and these are people that are in different areas of the theater. And the defendant states some words to the effect of throw popcorn at me or throw popcorn on my face. Yet when you listen to the defendant's taped statement, it never really brings up the popcorn. The evidence will show you that's important for ill will and spite. And when you see the way he lunges forward with the firearm and makes that statement, you get a clearer picture of what was really going on in the theater on January 13th.
That's how they're going to paint the defendant. And they say that's how the statements and the video is going to paint the defendant. You don't throw popcorn at me. This is what happens. Nobody's going to like that.
The defendant states in this taped statement that while he's back with his arm out, yelling, no, 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 or whoa, 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 and Chad's virtually in his lap, he's struck on the left side of his face. Remember, you're going to hear the defendant, prior law enforcement. Words and choices of words are important. The defendant states in this taped statement that he's hit on the left side of his face. Well, witnesses are going to tell you they never saw that. And the evidence will show you that almost scientifically, physically, it's not possible. Because the evidence will show you that Chad Olson was a row in front and a seat over to the right.
Once again, common theme you set up and keep saying becomes truer and truer every time you say it, all the way up and to the right. And now the defendant's making statements that are physically impossible and inaccurate according to the other statements and the video. That is damning.
and that it would be virtually impossible for him to do this hook that hooked all the way around from that distance across an aisle, all the way across seats, and struck the left side of the defendant as he was all the way back with his left hand out. The evidence will show you that simply did not happen. The evidence will show you there was no injury, as if he was struck that hard, because the defendant in his taped statement, you will learn, says he was dazed. But he wears glasses. You will see there is no injuries of any markings for glasses of being hit that hard that he felt he had to kill another human being. At some point in the taped statement, the defendant indicates he thinks that maybe a cell phone was at play because he saw the blur of a screen. Now, you will learn that a cell phone was found in front of the defendant, and it was in fact Chad Olson's cell phone. I submit the evidence will show you that it got there in one of two ways. One, because he was holding it in his left hand or his left side, and we know that because that was the side that was bothering the defendant. That when he stood up and he grabbed that popcorn, it fell over. Or, at the time he was shot, it was dropped. But the evidence will show you that no witnesses see anything remotely close to the defendant being hit with that phone, and there's no possible way that could happen. Now, another stipulation will be about this cell phone. This cell phone was also sent to the Florida Department of Law Enforcement. And there was some DNA testing done on this phone. Chad Olson's DNA was on the phone, but not the defendant's. Now, you're going to see pictures. The defendant did have some redness on his left eyelid, possibly the most fragile part of the human body. But the evidence will show you he had his glasses on, and the reason that his left eyelid, only his left eyelid, was red was because after the shooting he was rubbing his face and rubbing his eyes, and witnesses will tell you that.
That's the first reaction I've seen from the defendant. He almost smirked and shook his head like, yeah, right, that's why my eye was red.
He indicates he thinks there's something in his left eye. Paramedics check him out. There's nothing in there. They do a saline rinse. That's the end of the story.
So I didn't think that was a great point by the prosecutor. He's like, no injuries, no problem with him, but his left eye was red. I don't know. I don't like inconsistencies. I want to keep it as consistent as possible throughout the entire opening statement. I would have just gone with physically impossible for him to hit him in the left side of the face. Something else must have happened to make his eyelid red. And then maybe give that explanation. But don't say no injuries and no problems either, because that provides some inconsistency.
The defendant indicates in his taped statement that he second-guessed himself. He's sitting in the cruiser, and you're going to hear he says, I'm second-guessing myself. Did he hit me? This is the picture that's going to be painted for you during the course of this trial. The defendant also states, and I apologize for cursing at some point in his taped statement, and again, I apologize for the language, but oh shit, this is stupid.
That's about as professional as you can do it. Just I wanted to point that out. Just stylistically, I love it. That's how I do it. Apologize multiple times, but you got to say it to give it the effect. And that is also, we talked about it already, that is damning for the defendant to admit that this was stupid.
Now, for his actions, the defendant's been charged with 2 crimes. Murder in the second degree and aggravated battery. Now again, all of the jury instructions are going to be explained to you at the conclusion of the case. Now, suffice to say, this is what murder in the second degree is. What we have to prove to you is Chad Olson is dead. It was due to the criminal act of the defendant, and it was by an act that was imminently dangerous to another, demonstrating a depraved mind. And shooting someone at close range is an act imminently dangerous to another. That's not going to be an issue in this case. Did he do it with a depraved mind? That's where we fall back on the definitions that you're going to learn: ill will, hatred, spite, or evil intent. The other crime that the defendant's been charged with is aggravated battery. Now, going back to murder in the second degree, we do not have to prove to you that the defendant here intended to kill Chad Olson, just that he intended the act, which he did. This is not a case where it's an accidental shooting. He did intend to shoot him, and he died. We just don't have to prove he intended to cause Chad Olson's death. Now, aggravated battery, what we have to prove to you is that the defendant did intentionally, knowingly, and unlawfully touch or strike Nicole Olson against her will. Now, obviously, he didn't do that with his hands. He did that by using a gun and firing a bullet. So it's the same analogy. Did he touch or strike her against her will? And did he use a deadly weapon? Yes, a firearm is a deadly weapon. The other way that we could prove aggravated battery on Nicole Olson is, did he intentionally touch or strike her against her will? Yes. And cause great bodily harm, permanent disfigurement, or permanent disability? And the answer is going to be yes. You're also going to learn about an instruction called transferred intent. And basically what that means is if one person intended to do an act, meaning the defendant intended to do an act to one person, but ended up harming another. In other words, intending to shoot Chad Olson, but harmed Nicole Olson, be transferred intent.
He kind of stumbled over that, but you got to explain the statutes and what the defendant's charges, which he did a good job with, and then explain why you can also get intent to Nicole Olson, even though the defendant didn't intend to do anything to her. Because if he intended to harm Chad, you can transfer that intent to harm Chad to intent to harm Nicole. And that's exactly what it was. You transfer through. If you're intending to hurt someone, anybody you hurt, boom, you get that intent struck on them as well.
And that's how we get to the aggravated battery charge. Now, what is this case going to be about? Based on the facts that you were given at the beginning and during jury selection and the defendant's own taped statement, it's apparent the defendant is claiming self-defense. So you're going to hear a lot about self-defense. At the conclusion of the case, you're going to get all of the self-defense jury instructions. The question will be not whether or not this was an accident, because there's no evidence of that. It was an intentional shooting. Whether or not the defendant was lawful, whether or not he was justified in using that deadly force and killing Chad Olson. Now, this is basically what the self-defense instruction indicates.
So this is really important, obviously. It's a self-defense case. So now he's going to dive into what is self-defense in Florida. What does the defendant have to show in order to beat this guilty verdict because he admitted that he shot and killed somebody? And you can only do that in certain circumstances. Let's find out exactly what the language is that he has to prove here.
The use of deadly force is justifiable if Curtis Reeves reasonably, okay, and these are going to be important words here, reasonably believed that the force was necessary to prevent imminent death, he was going to die, or suffer great bodily harm, while resisting an attempt to commit a felony upon him.
Okay. Reasonably believed that his force was going to stop imminent death, meaning immediate or about to happen death, or serious bodily harm. Not way off into the future, not that Olson was going to go run to his car and grab a gun and come back. Had to be happening right then. Or to stop the commission of a felony, which maybe they're going to use something like that. I don't know.
In deciding whether or not the defendant was justified in the use of force, the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The evidence will show you those circumstances at the time that the force, meaning the shooting took place, was that another individual had tossed popcorn on him.
And by belittling and playing down the popcorn toss, which is true, I mean, he was throwing popcorn, not a gun. That's how you make it so preposterous that somebody would argue that deadly force was reasonable in a situation like this. That's why he's kind of flippant or almost sounds joking when he says it, because he wants the jury to realize that's nothing. That's no force, let alone deadly force.
The danger facing the defendant need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, under those same circumstances, would have believed that the danger, and the evidence will show you the danger was popcorn was just thrown on him, could be avoided only through the use of that force. So the question for you will be this: would a reasonably cautious and prudent person, that's 71 years old, because that's how old the defendant was, would a reasonably cautious and prudent person that's 71 years old, 6'2", 270 pounds, who's able to walk all around the movie theater, who has over 20 years of law enforcement experience, including 15 years on the Special Weapons and Tactics Squad, also known as SWAT.
Now he's breaking down the defendant's resume, and 6'2", 270 pounds and able to move around. That's no frail, old, weak man, in my opinion. I mean, I think the prosecutors are way ahead after this opening statement and how they laid out the evidence. Let me know if you agree.
Sitting inside a theater that by all accounts is going to be described as one in which you can see the environment, not pitch black like the movies, and not deafening loud. Reasonably believe that the danger could only have been avoided through the use of shooting Chad Olson. And the answer is going to be absolutely not. The evidence will show you there were some differences between Chad Olson and this defendant on January 13th of 2014. Chad Olson was 6'4". The defendant here is just 6'2". 2 inches difference. The defendant outweighed Chad by 65 pounds, but there was an age difference. The defendant was sitting an entire row back, an entire seat over. But the most important difference you're going to learn about during the course of this trial is that one of those 2 individuals brought a loaded firearm into a theater and shot and killed another person after popcorn was tossed on them. And that's this defendant. That's the one.
I thought he was going to say, and I almost paused it to guess, I thought he was going to say the difference is to the weapons that they brought to this fight, but maybe he didn't want to call it a fight, because if it's a fight, then maybe lethal force is acceptable. But he said one brought a bag of popcorn, the other brought a gun. That's what I thought he was going to say was the difference. The difference in the force used, maybe that's how I would have said it. Again, I haven't obviously reflected on what I would do here, but if I was him, I might have said the difference is also in the force used. One used a bag of popcorn, the other used a loaded gun. Something like that.
At the conclusion of this case, we're going to ask you to find the defendant guilty of murder in the second degree. And we're going to ask you to find him guilty of aggravated battery. Not because we're asking you so, but because the evidence that you're going to see and hear during the course of this trial is going to tell you that that is the lawful and just verdict in this case. Thank you.
All right, and that concludes the opening. Okay, it was a long video again, but it was fun to react kind of in real time without notes, not knowing what was going to come next, trying to guess kind of what he was going to do next. One thing you're not going to have to worry about at all in this case is the prosecutors being shady or scummy or doing something unethical. Same thing with the defense lawyers. We've got good lawyers on both sides, so I don't expect to see any foul play. It's going to be a fair fought battle here, and it's going to be interesting and fun to watch. Let me know what questions in the comments you have specifically about this case. Let me know what other parts of the trial you'd like to hear me react to and break down, and I'll be happy to do it. As always, make sure you like the video if you haven't already. Until next time.
Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.